Hi, everybody. Welcome to part 3 of our exclusive Freedom Project media presentation on the cultural, historical, and ethical history of abortion. Many people have talked a lot about abortion over the years, and there are so many really compelling scientific, not to mention moral arguments against the practice. What I wanted to do here is something a little bit different. People have gotten a little bit lost. Ever since 1973, abortion has been legal in America. It was legal earlier in European countries. But the minute something becomes legalized, we completely no longer discuss it as a moral issue anymore. Very often what happens in America or around the world is once we legalize something good or bad, then all real moral discussion seems to give way before the law. That's not what's supposed to happen. What's supposed to happen is the morality of a law, the justice of a law, the justice of a sociological issue has to come first. Regardless of law. Nobody alive today would argue that even when slavery was legal, it was a moral good. We would not argue that today. And I think the same argument can be made for abortion in spades. We've been making it here, and we're going to continue to make it today and then in part 4 coming up next week. And the major argument is going to be here that just legalizing it does nothing, it makes no comment whatsoever on the morality of the thing. And yet how many modern Americans, how many talking heads, how many progressives default to the fact that it's legal as their argument for why it should remain and why it should remain untouched? Leading up to our segment today, we talked a lot about the history of the cultural. We have all sorts of quotes. In my mind, it's a social justice issue. The left keeps lecturing us about social justice, about the most vulnerable being the most protected, about those without voices being enfranchised, given voices, those without advocates finding advocates. And yet when it comes to the unborn, these people become 100% cold and callous and heartless. The idea that a mother's life, and we remember that we're not talking here specifically about abortions in the name of keeping a mother alive or protecting a mother's immediate danger to her health. We're talking about the 99% of abortions that are nothing more than birth control after the fact. That's what we're talking about. And this idea somehow that you can give an individual's comfort level choice the priority over life of a living thing is staggering when you think about it. And so moving forward today, we ended the last segment on Roe versus Wade. We took all of this history right to Roe versus Wade. This is a social justice issue. Frame it in the left's own terms. Make the left defend it on the virtue of social justice. And at the very least, you can laugh as they hypocritically try to make a distinction between life in this instance and life in others. And so I told you last time we were going to spend a little time going through the ethical and moral and theological cases of abortion, now in regards to Roe versus Wade, which is stunningly bad law. If you want to make the argument that it's legal, shut up, it's legal, it's legal. First thing I want to point out about the Supreme Court decision in 1973 that legalized abortion, Roe versus Wade, 9 men in robes. 9 men in robes. We keep hearing from the feminists, we keep hearing from the left-wingers that men have no say in this issue, that men are not allowed to weigh in on this issue, that men can't be trusted on this issue, that men. And yet it was 9 men by a vote of 7-2, 7 men actually at the Supreme Court level, who voted this in on the most specious of legal terms. If legalisms are what we're defaulting to, let's take a look at just how bad the legalism of Roe versus Wade is. Roe versus Wade supersedes constitutional authority. And many have made this argument. In fact, many liberals, as you'll see before we're done today, many liberals, many stout pro-choice liberals in the 70s through today have made the argument that this was a huge setback for the court. That the legalization of abortion through Roe versus Wade was actually a step backwards for pro-choice advocates, and I think they're right about this. I don't have if I had more time, if I had a few more weeks and a couple more hours, we could go in a much greater depth into what all the constitutional issues are that have been raised by this issue. But Roe versus Wade, first and foremost, it supersedes completely constitutional authority. In other words, in order to get abortion legalized at the expense of states' rights. Some states were in the process of legalizing abortion. Other states took a very hard stand against abortion. Rather than let states make up their own mind about this, which is good constitutional law, the court came up with its own rationales based on the 14th Amendment right to privacy. Somehow, they teased from inherent rights to privacy in the 14th Amendment a right for women to have abortions, evidently in the name of privacy. This supersedes, of course, constitutional constitutional authority. In the U.S. Constitution, the power to make laws belongs exclusively to Congress. It is not the job of the Supreme Court to legislate. Since Roe versus Wade, by the way, we've seen a dramatic increase in the tendency of the Supreme Court to legislate in place of Congress. You could make an argument that perhaps the turning point in this kind of revisionist jurisprudence stems from 1973. In the U.S. Constitution, the power to make laws belongs exclusively to Congress. It is not the right of the Supreme Court justices to substitute their own policy preferences for laws enacted by the people's elected representatives. If you may remember that in 1973, it was the state of Texas that was being sued to get rid of its abortion laws. And in Texas, legislatively, by the power of the people and the will and the voice of the people, stricter abortion laws had been enacted, and that they decided was against privacy. The seven Supreme Court justices. The second main reason that this is a disaster for those who want to make the argument that it's the legality of abortion that makes us defend it. The right to abortion derived from privacy rights. As I just mentioned to you, it makes absolutely no constitutional sense. The premise of the Supreme Court is to interpret the Constitution, to use constitutional values to determine the legality of something that comes before it. In this case, that didn't happen. The idea that you had to go deep into the 14th Amendment to try to tease out some kind of a penumbra, some kind of an umbrella of meaning that would somehow cover the right of a woman to have an abortion at any term is pretty shocking when you think about it. Roe versus Wade finds a woman's constitutional right to privacy, to abort her child, quote, either in the 14th Amendment's concept of personal liberty, as we feel it is, they actually said, or in the 9th Amendment's reservation of rights to the people, right? So by that argument, so take the first one of those. We find the right to abortion, the seven judges decided, in the 14th Amendment's concept of personal liberty, because you're personally free. That's how broad it was. You're personally free to murder your baby if you want to murder your baby. There are 1,000 other things that can equally be squeezed under that realm that the left would want nothing to do about. Is it my personal liberty to enslave other races? Is it my personal liberty to engage in all sorts of things that they would never buy that for? But how much they stretch. And the second one's even more alarming. In the 9th Amendment's reservation of rights to the people. We ultimately want to devolve rights to the people. That's what the Constitution says. So because of that, we are going to devolve the right to murder babies to the people themselves. Right? So in other words, the very thing they pretend here is the right of the people, they denied the people in Texas. The people in Texas used their rights to elect legislators who enacted laws, pretty harsh laws against abortion. That was overridden by the Supreme Court in part because the people's will should trump the people's will. All right? And that's the kind of nonsense that you get. Next. Another major argument here about just a few of these. There's probably 15 or 20 reasons you can give why this is a dangerous precedent and bad law. But here's another one, the right to abortion. The right to abortion derived from privacy rights makes no constitutional sense. We just hit on that again in a different light this time. The court never examined the framers' intent. If you're going to make the argument that the 14th Amendment is the primary place that we find a constitutionally protected right to murder your babies, if that's the argument you're going to make, and you're going to cite the 14th Amendment to do it, it would help if in your ruling you actually cited or you actually went into what the framers of the Constitution meant by the 14th Amendment, which, of course, this court didn't do. The court never examined the framers' intent in the 14th Amendment vis-a-vis abortion, never argued how you could squeeze abortion rights, because, again, the rights of the woman in this case trump the rights of the unborn. How do you squeeze that in there? The 14th Amendment did not create new rights. In fact, if you look at the 14th Amendment, it was very specific. It did not create any new rights. It simply secured existing rights, primarily to African Americans and other minorities, the rights and liberties that had already been guaranteed by the Constitution. So in other words, since 1776 and beyond, the rights of the unborn were more or less protected along with the rights of the mothers. So what you're doing in the 14th Amendment, you didn't invent new rights. You did not invent out of that, the 14th Amendment, a new right to murder your baby. You simply extended much broader. The protections of the 14th Amendment, the protections of the Constitution, were spread much broader out through society. Of course, as the 14th Amendment was spreading the rights of life, start with that one. The right to life, to liberty, and the pursuit of happiness, as the 14th Amendment was trying to expand that, along come 7 justices in 1973 and says basically that expansion of rights expands to everybody but the unborn. And next, in our overview of some of the big problems we have with the Roe versus Wade argument, the court, this is another category here, the Supreme Court interpreted the 14th Amendment extremely broadly in favor of privacy to defend abortion, but it had adopted an extremely narrow definition of persons to be able to exclude the unborn children, right? This is a remarkable, only a lawyer can engage in these kinds of twisting, right? So incredibly broadly, the 14th Amendment had to be interpreted. So broad that it basically could have meant anything. So broadly is the 14th Amendment interpreted in Roe versus Wade that the stretch is so obtuse to get that in there, to get this idea that in that penumbra of all these existing constitutional rights that have been extended exclusively to minority peoples who've been disenfranchised in the past, we're going to add to that now the 14th privacy to destroy another category of person. But it also, the Supreme Court adopted a hugely narrow definition of what a person was, so as to exclude unborn children from protection. So on the one hand, you're broadening the rights so thin that pretty much anywhere, anything, anytime could be included under that penumbra. But when it comes to defining a person, you have so narrowed the definition that unborn babies alone are the only things that aren't protected by it. That kind of weak jurisprudence, that hypocrisy has been well called out down through the decades since we've labored under Roe versus Wade. And so, starting with the idea here. This is actually a kind of a commentary about Roe versus Wade. The Supreme Court, quote, ignored all the unchallenged biological evidence that individual human lives begin at conception, going all the way back to the ancient Greeks. As a matter of fact, the ancient Greeks are cited here. They are miscited. That Judge Blackmun, who was the Chief Justice, wrote the opinion, the majority opinion for the 7 men who voted for abortion, goes all the way back to the ancient Greeks. And his entire historical understanding of Roe versus Wade is completely muddled. What he says about Hippocrates, for instance, the Hippocratic Oath, that was ordered doctors, they took an oath not to engage in treatments that would lead to abortion. And, of course, the primary prohibition of Hippocratic medicine to first do no harm. All of these things, Judge Blackmun found a way to squeeze into a completely different vein. And so the Supreme Court ignored the unchallenged biological evidence that individual human life begins at conception. Quote, they even said, we need not resolve the difficult question of when life begins. That's literally what they write in the very short Roe versus Wade decision. We need not. It's not our job. We do not have to, the judges said, resolve the difficult question of when life begins. They said that, and then they turn around and did it. They decided more or less when life began. And they brought this ridiculous breaking up of life into trimesters. All of that is exactly what they said they weren't going to do here, right? Because if they had done that, if they had gotten into a serious philosophical discussion about when life begins, and they went back and did their homework correctly, as opposed to cherry picking and then misreading aspects of history in their favor, they would have found that there is a compelling bulk of evidence on from the argument, life begins at conception. That was ignored here. And again, what they say here, we need not resolve the difficult question of when life begins. This question is only, and they're not even qualified to do it, by the way. What qualifies a Supreme Court justice to determine such things? On the one hand, they say they're not going to do it. We don't have to do it. On the other hand, they do it, as we'll see in a moment. And yet, as others have pointed out, this question can only be determined by science, not philosophers or theologians or politicians. Ignoring the actual issue, the court sidestepped the question and legalized abortion anyway. And so here's the difference. Back in Hippocrates' day, back in the Middle Ages, back in the Renaissance, back in the time of the Victorian era, these are all areas of history that more or less were cited in the Roe decision. Interesting thing about them is they didn't have the kind of science we had between, say, 1950 and 1973. Tremendous scientific advancements right up into and including the year 1973 demonstrated more and more and more that a child, a baby, is more obviously human, is doing more obviously human things at much younger ages. And that science has continued unabated to today. The more we study unborn babies, the more remarkable we learn things about how developed they are, how much they're capable, how many aspects of them, of their humanity, are present even from the earliest months. And that's a shocking thing when you think about it. Only science can make that distinction. We've never had more science than from the period of Roe versus Wade to now, even slightly before Roe till now. And that science is not going the way of the pro-abortionist. It's not. And this is a difficult sticking point when you stop and consider the fact that these Supreme Court justices were going all the way back to Hippocrates to rewrite Hippocrates to fit their narrative, and yet they don't spend almost any time talking about the viability science as it existed, which was pretty extensive. And so you see, again, a huge problem with how this goes. And so, ignoring all that, the court sidestepped the question and they legalized abortion. How about this? The Supreme Court legislates to establish trimesters. I've already mentioned to you how the Supreme Court just got through saying that we are not going to get into this age-old discussion. It's not our job to try to solve the problem, and then they did it. They broke up a developing baby's life in the womb into 3 different trimesters. For some reason, on the basis of what exactly nobody knows, it's completely and utterly guesswork. It's throwing darts at the proverbial dartboard. It is no real viable argument for this. And then the other thing that's so maddening is they really don't give you any argument why the trimester system as opposed to any other system. Why not a monthly system, or why not weekly systems? We just don't know. They never bothered to go into it. So they say they're going to do one thing, they don't do it. They cite history only to twist the history and get the history wrong. They say that they can't do something, and yet that is exactly what they turn around and do here. Roe versus Wade. They determined that for the first trimester of pregnancy, the first 3 months, privacy interests, right? The idea that for the first 3 months of a developing baby, the right of mothers to privacy, as devolved from the 14th Amendment in the most inscrutable of ways, that overrides state regulation. So vast majorities of duly elected individuals by the people of the United States in various states had been totally disenfranchised by the fact that somewhere in the murky first 3 months of pregnancy, a mother's right to privacy trumps state lawmakers, trumps the voice of the people. And if that's the case, why just for 3 months? Why doesn't that happen? And as we will see shortly, it did. That 3 months of absolute protection of mother's privacy kept creeping and creeping forward. But Roe determines that for the first trimester of pregnancy, privacy interests override state regulations, which is a shocking statement. From the end of the first trimester to the time of viability, and that's a word they throw in here, right? Which they decide is no earlier than 26 weeks. So from the same court of non-doctor men who basically say they are unqualified to be able to postulate when life begins, and who go back to history to misread history very blatantly, they decide all of a sudden that from the end of the first trimester to the time of viability, no earlier than 26 weeks, states are allowed to regulate abortion practice only related to advancing the mother's health. Here's another problem. What is the mother's health? As we have found out in the intervening decades since, that this has become a huge win, not just to expand abortion well beyond the first 3 month period, but to argue that any aspect of a woman's health, not just health of body or health of or her life was going to be at stake, but even her mental or her psychological, even, it has been argued, her cultural health. If it's going to cause her cultural harm to give birth to a baby, well, that's significant enough harm to warrant destroying babies well beyond that initial 3 month period. If you go back to it, from the end of the first trimester to the time of so-called viability, no earlier than 26 weeks. And again, not a single argument as to how they came up with that explanation, justification, no historical evidence for any of this. States are allowed, understand the language. In the second trimester, states can regulate abortion, but only in the matter of advancing a woman's health. We have now, progressive activists have now so twisted this argument that any reason the mother gives is a healthy reason. And so in other words, the states aren't supposed to be able to regulate abortion at all. Many states have been able to do it, and there's court battles back and forth. But as we see abortion rights and the fetish of abortion that we see among the progressive left, these are the kinds of things that are being exposed. Barack Obama was one of only, I think, two maybe senators, maybe one or two state senators when he was Senator Obama from Illinois, who actually signed onto a piece of legislation that would have given which would have given born babies that were born in the process of abortions, babies that were so far along that they were in the process of being born. If those babies escape the mother's womb and then escape to breathe air and become no longer dependent on her body, Obama signed a piece of legislation, was on board with killing the baby or not letting it live, letting it starve to death, putting it in a closet somewhere so that the mother's absolute right to an abortion would be protected. So again, the creeping idea that abortion after the fact is exactly what some of our more radical progressives want. Go back to the quote. So, in the second trimester, the state can only, says Roe versus Wade, limit abortion to the degree that it benefits a mother's health. And in the final trimester, the last 3 months, late-term abortion we would call this, the state can protect the potential life of the child. So this is interesting. These 7 black-robed justices, these 7 men have decided that for the first 6 weeks, for the first 2 trimesters, the first 6 months, that the protections for the mother's health outweigh the baby's rights. And then in the final trimester, the argument being that viability, in their own words, has clearly been attained in the last 3 months, and yet they call it only potential life. Everything about this is so backwards when it comes to clarity, when it comes to professionalism, when it comes to judicial gravitas, when it comes to competency. So even in the last 3 months of life, it's only potential life, right? But how can viable potential life? What differentiates the 26 weeks from the final 3 months? It's now just potential life of the child by regulation, except where necessary to preserve the mother's life or health again. So even in the final 3 months, that the state's rights, the people's ability through their state governments to limit abortion in late terms, the last 3 months, is overridden not just by the life of the mother, if a mother's life is in danger of giving birth to that child, but also the health of the mother, which again, as we have seen, they took all this time, the Supreme Court, to go back to Hippocrates, but they couldn't be bothered once to address what is meant by health here in a specific way. And so consequently, the broadest possible interpretations for the broadest possible abortions, even potentially abortions after birth, were put on the table here. Bad legislation. Go to the next slide. So starting right away in 1973, all sorts of people, primarily liberals, I'm going to spend the rest of my time giving you primarily liberal arguments against Roe versus Wade by people who are redoubtably pro-choice, who believe deeply in a woman's right to destroy her child, and yet they recognize that to do it this way is an act of constitutional disentitlement. You are disenfranchising people. You are overriding all sorts of time-honored constitutional values that make America America. This is Byron Whizzer White. This was one of the 2 Supreme Court justices who actually wrote against the minority position against Roe versus Wade. And what Justice White says is really remarkable. He says, I find nothing in the language or the history of the Constitution to support the court's judgment. It's amazing, as we'll see in a moment, how many liberal progressive voices make the same argument. I find nothing in the language or the history of the United States Constitution that supports this court's judgment. The court simply fashions and announces a new constitutional right for pregnant mothers. And if you were going to do that, you should have had to forget the courts. You should have had ERA activists or progressive activists or abortion rights activists get together and try to get a ballot initiative going, get a number of states to amend the Constitution, the House, the Senate to ratify this new amendment. Then you could have had something, but that wasn't done because they knew it couldn't be done. You couldn't get that done today, not by a long shot. In today's permissive abortion culture, you could not get a constitutional amendment. No way could you get one legalizing abortion. So what did they do instead? Go back to Byron White. The court simply fashioned and announced a new constitutional right for pregnant mothers. And with scarcely any reason or authority for its actions, it invested that right with sufficient substance to override most existing state abortion statutes. They completely eradicated states' rights with this issue. And if you can do it with abortion rights, you can do it with anything if you want to. You can make the same arguments. The upshot is that the people and the legislatures of the 50 states are constitutionally disentitled to weigh the relative importance of the continued existence and development of the fetus, on the one hand, against a spectrum of possible impacts on the mother, on the other hand. No ability for the states with elected representative governments, majority states opposed to abortion in huge percentages, no ability now, they've been completely disentitled, no ability for them to weigh in on such an absolutely fraught issue, an issue where you could make arguments on both sides rationally. As an exercise of raw judicial power, the court perhaps has authority to do what it does today, maybe. If the purpose here is to demonstrate that the Supreme Court has the power to override states' rights and individual voices, perhaps they have that right, but in my view, its judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court. It is extravagant, it is over the top, it is unwise, it is a dangerous assertion of the overreaching powers that the Constitution, or these justices think, the Constitution extends to this court. That's a pretty serious objection, and it's an objection based on law and morality. These justices whose job it was to interpret the rights of the aggrieved parties, be they unborn children or be they mothers, pregnant mothers, ignored all of that to create a new entitlement, supra-constitutional new entitlement, and to limit it, and to, in the most broadest possible way, open that door while closing down personhood, what personhood means to unborn children. That's how they got it done. And if you are a liberal, you ought to be disgusted by this. And here's the other thing. You can, and many of the voices I'm about to share with you will argue that as a pro-choice person, they'll say, I suppose we should be grateful for Roe versus Wade, but we did it the wrong way. We empowered Christian fundamentalists and other people. All that's true. But here's the thing that I want to point out to you right away, that if 1973 had done its job and concluded that we have no viable ability to assess when life begins, and so therefore we can't take this case, therefore we must default back to the will of the people, the voice of the people as manifested in their state legislatures. If they had done that, some states no doubt would have quickly legalized abortion, others would not have, but you wouldn't be in the situation you have now, where states have been prohibited for more or less of the last 40 years from being able to act their own responsive legislation vis-a-vis their own populations. And so you have a terrible disentitlement going on here, as Whizzer White said. Go to the next one now. Now let's take a look. How about Ruth Bader Ginsburg? How about ultra-liberal, ultra-pro-choice Supreme Court justice? Still on the bench. In her estimation, Roe versus Wade, quote, is a heavy-handed act of judicial activism. It is nothing more than judicial activism. If somebody like Ruth Bader Ginsburg, who has engaged in judicial activism for the court for 30 years now, if someone like that can call Roe versus Wade an actual example of heavy-handed activism on the part of justices who have no lawmaking capacity whatsoever and who certainly have no medical degrees with which to make these decisions and certainly don't have history on their side, that is a titanic, heavily active judicial activism, right? And if somebody like that can make that argument, that's pretty telling. You move a little bit further. Lawrence Tribe, right? The guy who came out recently and basically argued if you're going to impeach Donald Trump, shoot to kill, right? Had to apologize for his gun metaphor about killing the president. This is the guy who defended Al Gore in the 2000 election. Redoubtable left-winger, huge pro-choice advocate. Here's what he had to say about this. All right, speaking of Roe versus Wade, behind its own verbal smokescreen, the substantive judgment on which it rests is nowhere to be found. Despite all of the sleight of hand, despite all of the verbal tells, despite all of the twisted, tortured logic of a relatively short decision, Roe versus Wade, there is no substantive judgment on which all the words stand. This made-up right isn't a right. You are twisting the Constitution to privilege a political position here, an ideological position. There's nothing else to say about it. Lawrence Tribe is right. Behind its own verbal smokescreen, all the word soup the justices threw to try to defend what they were doing, behind its own verbal smokescreen, the substantive judgment on which this decision rests is nowhere to be found. You cannot find it. You can't even find a toehold. You're a big radical lefty like Tribe, or you're Ruth Bader Ginsburg. These jurists know there's not even the tiniest of footholds on which to build the arguments you build to legalize abortion for the first time in American history. Moving from Lawrence Tribe, We go to Edward Lazarus, who was Harry Blackmun's clerk, who clerked as a law clerk for Blackmun, who was the Supreme Court justice, of course, who gave us this misguided ruling. Here, he's pretty definitive about this. He's a big pro-choice guy, loves abortion, loves a woman's right to choose to murder her baby, and is very just nonplussed by the lack of legalism, the lack of legal standing for this decision. He says, as a matter of constitutional interpretation, which is the entire thing that the Supreme Court is meant to do. There's not much else they're asked to do. If you're not interpreting the Constitution, doing your best to try to be faithful to its statements, to make sure that our rights and responsibilities given to us through those documents are protected, what are you doing on the court? You're activating. You're behaving as an activist. As a matter of constitutional interpretation, even most liberal jurisprudence, right, justices, if you tied the progressives, if you tied them down and forced truth serum in their veins, make them tell the truth, they will tell you that this case is basically indefensible. There is no way you can defend it. And I love what he says there. He's pointing out that liberals would rather die than admit that abortion became a right and then it became a sacrament, not on the basis of anything other than cheap arguments, rhetorical sleight of hand, bad arguments, and unconstitutional values. Go a little bit further with Lazarus. He goes on, he says a little bit more about this. He continues, what exactly is the problem with Roe? The problem, I believe, is that it has little connection to the constitutional right it purportedly interpreted. There is no argument you can make, however twisted, that's going to make it look like the 14th Amendment was written in part to protect mothers' rights over unborn babies. You can't do it. In fact, it's the most vulnerable, again, the most previously voiceless, that the 14th Amendment tries to extend the existing protections of the Constitution to. The problem, I believe, is that Roe v. Wade has little connection to the constitutional right it purportedly interprets. A constitutional right to privacy, broad enough to include abortion, has no meaningful foundation in constitutional text, history, or precedent. You can't even cite goofy liberal precedents down through the ages that would justify this kind of overreach from our 7 justices. At least, it does not if those sources are fairly described and reasonably faithfully followed. In other words, you have to engage in the worst kind of judicial malpractice to tease out these kind of meanings, to justify what is nothing more than an advocist, activist, radical political position. That's all there is to it. Go back to this again. If we fairly and reasonably interpret not just the Constitution, but the history of the Constitution and the precedents that have grown up in the wake of the Constitution, there's no way under text, history, or precedent to make this stand. William Salatin, radical lefty, Slate columnist, used to be a moderate Republican, actually left the Republican Party a number of years ago, decades ago, precisely because he was a pro-choice person who could not stand the Republican Party's generally speaking, anti-choice platform. Pro-abortion platform. Here's what Salatin said in Slate, which is about as left-wing a magazine as you're going to get. Quote, Blackmun's Supreme Court papers vindicate every indictment of Roe, every nasty thing conservatives have said about Roe, every shocked thing that lawyers of all political parties say about the horrible nature of the decision in Roe. That when you look at Blackmun's papers, when you look at Blackmun's reasoning, you look at all the materials he was considering, you look at everything he wrote about the case, all of it, every bit of it vindicates the despicable way that we hate it. It proves that it was bad. Blackmun's Supreme Court papers vindicate every single indictment of Roe versus Wade. Its invention, how it made up rights, its overreach, going way beyond constitutional parameters, its completely and utter arbitrariness, how it can say one thing, privacy is extended hugely, 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 at the expense of personhood, which is reduced minutely, minutely, minutely. Everything about Roe versus Wade, its invention of new rights, it's the thought behind it, its executive and judicial overreach, its complete random arbitrariness, its complete indifference to what words mean, what texts say, what the Constitution says, to all sorts of medical history, to biological science. All of that was thrown out the window in a very cheap, very glib, very short testimony to judicial overreach. Furthermore, we go a little bit further. John Hart Eli, who up until the time of his death was considered, who's probably the second most constitutional scholar of his day, and incredibly well respected, a constitutional scholar at Yale, Harvard, Stanford Law School, who was, again, one of the most cited for his legal prescience. He said, quote, "Roe is not constitutional law, and it gives almost no sense of an obligation to try to be. It is not a constitutional a law based on the Constitution. It is an anti-constitutional piece of legislation. It is wrong, and it doesn't even pretend that it's going to consider the Constitution seriously." This was activism before the case had ever reached them. This was a decision that was made on feelings, on political pressure. It had nothing to do with the constitutional precedent, nothing to do with the history of these complicated issues at all. And for somebody like John Hart Eli, who is a remarkably even-handed jurist, it's one of the reasons why he was so famous in his day and so well-cited in his day. For him to say Roe is not constitutional law, and it doesn't even pretend to be constitutional law, is damning. This is a much longer quote from Eli. It's powerful. He says, "What is frightening in the Yale Law Review, no less, Law Journal, what is frightening about Roe is that this super protected right is not inferable from the language of the Constitution. You can't find a way to trace this made-up right, which is now super protected." That's exactly right. It has been inoculated from criticism because it's law, because powerful abortion advocates, Planned Parenthood, sucking off the teat of the federal government, making $500 million a year off the very taxpayers who've been disenfranchised by Roe versus Wade. The various state governments that have been silenced to be able to meet the concerns of its own citizenry by Roe versus Wade. What's frightening about Roe is that this super protected right is not inferable. You can't make a case. You can't draw a link from the language of the Constitution, from the framers' thinking respecting the specific problem in the issue, from any general value derivable from the provisions they included, or from the nation's governmental structure. There's nothing in the United States government, the way it's set up, the way it's functioned for 200 years, there's nothing that would justify this kind of an interpretation. It is flat out illegal, superlegal, beyond legal. It's not legal at all. And simply because 7 men in black robes insist upon it, it has become a hallmark of the legal protections for women in the Constitution. It's such a joke. Nor is this law, this ruling, explainable in terms of the unusual political impotence of the group judicially protected, i.e., women or even babies for that, unborn babies, vis-a-vis the interest that legislatively prevailed over it. At times, the inferences the court has drawn from the values the Constitution marks for special protection have been controversial, even shaky in the past. Some courts have done controversial, even dubious things, but never before Roe has its sense of an obligation to draw one been so obviously lacking here. This was an out-and-out ignoring of the Constitution to make their point from one of the most respected constitutional lawyers in the last 50 years. And now you've got Washington Post columnist Benjamin Wittes, who makes an obvious argument, right? The title of the article is "Letting Go of Roe." Stay pro-choice, he argues, just get rid of Roe. But here's the problem with getting rid of Roe, is what I've already said. If you get rid of Roe now, it doesn't matter. The problem with allowing Roe to go through was it set a precedent. And how many really equally bad and worse decisions have been based on that precedent? You can't just get rid of Roe. If you get rid of Roe, you got to get rid of all the legislation that followed in the wake of Roe, which is to completely gut the argument for abortion, which was never really a compelling argument to begin with. Wittes says Roe is a lousy opinion, that he even has to admit this, that disenfranchised millions of conservatives on an issue about which they care deeply. And of course, the left would brand anybody who's pro-life, including Democrat pro-lifers, as conservatives. This is the disenfranchisement of what at the time was a majority of Americans. And if you believe recent surveys, a majority of Americans have significant problems with many aspects of abortion today. As I said before, there's no way you could get Roe versus Wade passed as a constitutional amendment. You still couldn't. despite all the so-called love of abortion in this country. You could not get anywhere near the votes to make that happen. And yet, Benjamin Wittes is right here. Roe is a lousy opinion, and it didn't create any constitutional clarity. It didn't create any sense of justice. It did not mitigate the problems with the issue. It simply disenfranchised people who disagreed with them. Richard Cohen from the Washington Post. Quote, "The very basis of the Roe versus Wade decision, the one that grounds abortion rights in the Constitution, strikes many people now as faintly ridiculous. Whatever abortion may be, it cannot simply be a matter of privacy." Again, when you think about the absurdity of this, it seems to me one of the least private things moving forward in biology is a pregnant woman. Right? After the first month, it becomes increasingly not private. It becomes something that is much more public. The fact that it takes a husband or a father or a man to impregnate the woman demonstrates that the baby was not conceived in any manner of privacy. And that led to what? To the excluding the rights of the father from all of this as well, too. In trying to, one of the negative consequences of this goofy legislation was to validate the argument that privacy defends a woman's right to be able to consult or to have to take into account the feelings or the sensibilities or the wishes of any father or husband, to completely disenfranchise them as well. Go back to that. The very basis of Roe versus Wade decision, the one that grounds abortion rights in the Constitution, the only one that comes anywhere near a constitutional argument why abortion should be legal, it strikes many people now, not 50 years ago, 40 years ago. Now it strikes people as ridiculous. Whatever abortion may be, it cannot, by definition, simply be a matter of privacy. You could make the same argument that slavery then was simply a matter of privacy. Private families had slaves that were private slaves. They didn't belong to the state, they belonged to the federal government. Therefore, they belong to the family. Therefore, we can't overturn slavery. We can't emancipate slaves because it's a privacy issue. We would laugh in the face of that. When it comes to murdering babies, we're not laughing at all. We're dead serious. Richard Cohen continues, "If a Supreme Court ruling is going to affect so many people, then it ought to rest on perfectly clear logic and up-to-date science. There is no logic, there is no rhyme or reason, there is almost even no sense whatsoever in how Roe versus Wade was written, and science is one of the few things that isn't really consulted. The only real mention of science in Roe versus Wade is to make the argument that science itself doesn't know for sure, nor is it necessarily the providence of science to be able to comment on the morality of murdering babies in the womb. If a Supreme Court ruling is going to affect so many people, including 70 million aborted babies in the last 40 years, if a Supreme Court ruling is going to affect so many people, then it ought to rest perfectly clear logic and up-to-date science. Roe, with its reliance on trimesters and viabilities, made-up terms, words that has no real medical value, has a musty feel to it. And its argument about privacy raises more questions than it answers." And we've got another quote from Cohen to extend the argument. Quote, "Roe is a Supreme Court decision whose reasoning has not held up. It seems more fiat than argument." Bingo. It is more order. It's something a king would dictate. It's something that a dictator or a tyrant would enforce, much more than it is an argument. Still, he says, however you parse this, however much it worked out for lefties like Cohen and people on his side of the pro-choice argument, still, a bad decision is a bad decision. If the best we can say for it is that the end justifies the means. That's what progressives say. Again, they won't buy our moral arguments. They certainly won't buy biblical arguments. They won't buy the argument, right, that the same arguments progressives make to protect all sorts of other kinds of vulnerable life, they won't extend to the most vulnerable of all human life, babies. Nevertheless, what Cohen says is exactly right here. If our whole argument, and it's the only argument the left has, if the whole argument is that the ends justifies the means, however bad, however illegal, however unconstitutional, however unfair Roe versus Wade was, it gave us what we wanted. If that's your argument, Cohen says, then not only have we lost that argument, but we've lost a bit of our soul as well. We've sold our soul to the devil. We have given up any moral high ground. And that's been the left's position on this ever since Roe versus Wade. As more and more radical extremists are demanding more and more late-term abortions, as the sitting president was all for allowing babies born in the process of a botched abortion to simply wither away and die under a blanket somewhere, as we become more extreme in funding ridiculous organizations like Planned Parenthood, whose primary purpose is the destruction of babies. Or whatever, all these mammograms they're farming out to non-Planned Parenthood places can't make up for the fact of what they're doing beyond this. What Richard Cohen here says is right. You've given up your souls. You are a soulless bunch. You are an inhumane, soulless bunch of ghouls. You can pretend to masquerade that any way you want to. There's nothing other than the fake quasi-legalism of that court decision, the counter-intellectual decision that was made in 1973 that justifies all subsequent matters of abortion and abortion funding and the cutting out of the rights of those who want to protect the lives of innocent children. You go further here. Alan Dershowitz. We all know Alan Dershowitz. Harvard Law, arguably the one lawyer most Americans could name. If you were put in a room, sat down with a typical American and asked him to name one high-powered lawyer, this is probably the only one they'd come up with. He is a redoubtable Democrat. He is a predictable liberal. And yet, he puts the law before his own personal politics. He's doing it with Trump now, right? One of the few voices to argue that this case being made against Trump is not legal. And nevertheless, Dershowitz said this, going back to 2000, 2001. Judges have no special competence, qualifications, or mandate to decide between equally compelling moral claims. And at least he's honest. For every quote-unquote moral argument about a woman's right to choose, you have at least as many moral arguments about the right of a baby to live. Judges have no special competence, qualifications, or mandate to decide between equally compelling moral claims, as in the abortion controversy. Clear governing constitutional principles are not present in either case. In his mind, not in the Roe versus Wade or the decision that made George Bush president. He was comparing the court decision that gave Bush the presidency over Al Gore in 2000 and what happened in Roe versus Wade. And in his conclusion, that the courts were not qualified to decide either of those. And if they're not qualified, if the court isn't qualified to decide those things, you have to default to states' rights. You have to default to the right of the people to have their will be done. That's what the Constitution says. Any of these rights and responsibilities that cannot be satisfied in federalism from the federal government's perspective have to belong to us, the people. All right, and if you had not had that happen, if we were back in 1973 and the states were allowed to decide, I guarantee you today that the majority of states would still be against abortion. You go further. Cass Sunstein, University of Chicago Democrat, law professor, Democrat judicial advisor. She's constantly advising Democrats on which Supreme Court justices to pick for their nominations, said this: in the court's first confrontation with the abortion issue, it laid down a set of rules for legislatures to follow. The court decided too many issues too quickly. The court should have allowed the democratic process of the states to adapt and to generate sensible solutions that might not occur to a set of judges. Let the people decide it, not men in robes. Jeffrey Rosen, legal affairs editor of The New Republic, said this: in short, 30 years later, it seems increasingly clear that this pro-choice magazine, The New Republic, was correct in 1973 when it criticized Roe on simply constitutional grounds. And this is the thing that gets, as much as Rosen is for abortion, he has to admit that abortion was legalized unconstitutionally. Its overturning would be the best thing that could happen to the federal judiciary, the pro-choice movement, and the moderate majority of the American people. And I don't believe that. I don't believe the modern majority of America. In fact, I think it's exactly the opposite. The moderate majority of American people support pulling back most abortion rights. Nevertheless, he's right about this, that if this is the only thing on which we've based our argument, as the previous fellow said, that we lost our souls, that you've done a huge disservice to the country. Rosen continues, 30 years after Roe, the finest constitutional minds in the country still have not been able to produce a constitutional justification for striking down restrictions on early-term abortions. That is substantially more convincing than Justice Harry Blackmun's. No lawyers, not the greatest legal minds of the last 30, 40 years, have been able to come up with a better reason to justify this than Harry Blackmun's. And Blackmun's was, we've seen time and time again, a joke. No one's come up with anything better than the joke that Harry Justice came up with. He calls it the famously artless opinion itself. As a result, the pro-choice majority asks nominees to swear allegiance to the decision without being able to identify an intelligible principle to support it. We're asking Democrat candidates now to support Roe versus Wade or they won't get elected by the left, without being able to make a single argument or intelligible principle that would make it worth supporting. This is absolute malpractice from the perspective of those 9 judges. Michael Kinsley, radical lefty progressive pundit on Crossfire for a lot of years, fighting with Buchanan from the left. He said this, quote, in 1994, against all odds, and I'm afraid against all logic, the basic holding of Roe v. Wade is secure in the Supreme Court. A freedom of choice law would guarantee abortion rights the correct way, democratically, rather than by constitutional origami. This is nothing more than folding the Constitution into all sorts of strange shapes, right? Origami in the name of twisting rights that are not protected in the Constitution and forcing them on the public at large. Michael Kinsley continues, although I am pro-choice, I was taught in law school and still believe that Roe versus Wade is a muddle of bad reasoning and an authentic example of judicial overreach. I also believe it was a political disaster for liberals. Roe is what first politicized religious conservatives, while cutting off a political process that was legalizing abortion state by state anyway. And he was right. In 1973, some states had begun the process of legalizing abortion, but the vast majority either prohibited it or were strengthening prohibitions against it. Kinsley wants to argue that if you'd left it to the democratic process, which we should have done anyway, that abortion would have won in the end. I counter that it wouldn't have. You would have had none of the precedents, none of the bad legal cases in the wake of Roe versus Wade. I disagree with him on that, with arguing he's dead right. It was the worst thing that happened to the left. He's also right about the fact that it politicized religious conservatives who weren't into political battles. It made this opposition stand stronger, recognizing that we on the conservative right have been completely disenfranchised in a way that there is no constitutional precedent for whatsoever. When you stop and think about this issue and how contentious and important this issue, that life is at stake. Again, 70 million aborted babies in the last 45 years that have no say. What they could have been, how life could have been different if there had been a fair play. How many abortions wouldn't have occurred if we took Kinsley's route, right? Let the democratic process try to deal with it. How many states would have protected the lives of how many babies? How many African-American babies? We want to talk about the 14th Amendment, and the 14th Amendment making sure that African-Americans had the same kind of rights that the Constitution had promised originally in 1776. How many black babies might not have died to the abortion mills if, think about Planned Parenthood we talked about last time and Margaret Sanger using abortion as a tool to weed out black and Hispanic populations and how damn successful they've been at doing this, right? You think about what kind of real protections the 14th Amendment could have protected those unborn babies if it weren't twisted to provide a privacy reason to justify abortions. Next time on the show, we have a real special treat for you. We're going to talk to Steve Deace. Steve Deace is a profound anti-abortion advocate. He is one of the great apologists for life. He debates this matter better than anybody I've ever seen. So in part 4 of our talk, we will deal with the practical consequences of abortion in a very meaningful way. We will see you next week.